Hi, welcome to this workshop. My name is Martin Williams. This is the recording for a workshop from the conference in CPAG conference in 2025 called What's Fairness Got to Do with It, where my topic is procedural fairness in the First-tier Tribunal. Okay, so in terms of what we will cover, I'm going to talk firstly about why fairness in the First-tier Tribunal matters. Secondly, I'm going to talk about the legal sources of procedural fairness, and from that to talk about the content of procedural fairness. So what does it mean for a tribunal hearing to be fair, or tribunal process to be fair? I'm going to try and make good on the idea that for a hearing to be fair, it requires that you have an opportunity to present your case and that there be no bias. Having run through in some detail what it means to have an opportunity to present your case and for there to be no bias, we're then going to just cover off looking at how advisors can look to achieve procedural fairness in practice. So both things you can do when you're in the first-tier tribunal to try and ensure a case is dealt with fairly, and also things you can do to challenge a first-tier tribunal decision should things not work out, i.e., should it be, or should you be able to argue that the result is unfair? Okay, but let's just start briefly with why fairness matters. And I guess what I want to say here is you can seek to explain fairness for its own sake, that it's not right that people are treated differently when they should be treated the same. It's not right that people don't understand the process they're going through. Anything like that would be, just in and for itself, fairness matters, because it's not good when things are unfair. I don't want to approach it that way. I work for an anti-poverty charity, and obviously charity is concerned about the rule of law, fairness, and those things. But the reason we're concerned about that is at least in part because in order to make sure people get what they are entitled to, we think that in general they have the best chance of getting that when the process which decides whether or not they get it is a fair one. It should also be noted, I suppose, that, sometimes it's fair that your client doesn't win their case. Fair tribunal is not the same as a tribunal which your client wins. Okay. So for me, fairness is the best way of winning an appeal, is for things to be fair. Or at least that's a basic requirement to give you the best possible chance of winning your appeal. Let's talk then about the legal sources of procedural fairness. I'm going to run through these now. A starting point always has to be the set of procedure rules made by the Tribunal Procedure Committee, so Committee of Tribunal Judges, which regulate the procedure of the first-tier tribunal. So tribunal procedure, first-tier tribunal, social entitlement chamber rules. The other thing to say is sometimes, the tribunal procedure rules are going to be a first stop for looking at the content of fairness very often. Okay. We also have those sometimes built into the benefit rule that the appeal is about. We have something to do with fairness. Finally, two other sources of procedural fairness. One is that the English and Scottish common law has a concept of natural justice, which is very much about fairness. And finally, Article 6, that's the right to a fair and independent tribunal within a reasonable time in the determination of your civil rights. That article within the European Convention of Human Rights, so brought into British law by the Human Rights Act 1998, also requires fairness. Okay, so different legal sources of fairness. I want to go through those different legal sources in a little bit more detail. Okay. So when we look at the tribunal procedure rules, sometimes we find that there's something about a particular rule that builds in the idea of fairness. And more generally, we'll see that the idea of fairness flows into the rules, and therefore everything a tribunal does under the rules via the overriding objective of the rules. So I'll explain that in a moment. But first, I haven't pulled them all out, but just, briefly, some of the places the procedure rules build in fairness. First one I've picked out is Rule 8. Paragraph 4 of that rule requires that in general, before an appeal is struck out, then the appellant is given an opportunity to, or must be given an opportunity to make representations about whether it should be struck out. The only exception to that is where the appellant knew it would be a consequence of something they had failed to do, that a case would be struck out. So if the Upper Tribunal gives you a direction saying, unless you do this, your appeal will be struck out, then it is indeed struck out. But you do have, in any event, a right to get it reinstated. So those are a right to get it, to ask for it to be reinstated. So Rule 8 builds in fairness by stopping them, ending your appeal before you've had a chance to comment in general. Okay. Rule 24. This is the rule about responses and replies to appeals. And that requires the decision maker to give your claimant all of the documents they had relevant to the case as part of their response to the appeal. And it also gives you at least a month to file any reply to that. Similarly, Rule 27 deals with fairness in the sense that it gives you your right to attend a hearing. Okay, so they must hold a hearing unless both parties have not objected to and the tribunal considers it's fair to decide it without a hearing. Or Rule 28, which is a related rule, which says if there is a hearing, you're entitled to go to it. Okay, Rule 31 then deals with the power of a tribunal to proceed when you've not turned up at a hearing. So you can see that all of those are rules which are allowed or designed to make sure your client is fully informed about what the decision made against them is about, and also to make sure that they can take part in the appeal. Okay, if you don't find built into the rule in the procedure rules a specific thing, then obviously there is also always Rule 2 of the procedure rules, which says that, look, the aim of these rules, the overriding objective, their purpose, is to enable tribunals to deal with cases fairly and justly. And the way in which that overriding objective is forced upon the way the rules work is the rules go on to say at para 3 of Rule 2, whenever the tribunal uses any power, exercises any power given to it under the rules, then it has to remember that the purpose of the rules is to enable it to deal with cases fairly and justly. Okay. Now, the rules also at Rule 2.2 set out a little bit about what dealing with a case fairly and justly means. Wherever you see a word like that highlighted in Para 2 or italicized in Para 2, it includes, that means it's at least these things. It doesn't mean that is the entire content of what dealing with a case fairly and justly means. Okay, so it's these things like dealing with a case in a way which is proportionate to the complexity of the case, costs, resources of the parties, and so on. Dealing with a case fairly and justly includes that, but it can include other things, making sure the claimant has been able to understand the evidence against them. For example, not strictly speaking in that list, maybe it's necessary to ensure the claimant is under Rule 2.2c to ensure the party is able to participate in the proceedings. But you could say it's not fully within the list, but that doesn't mean it's excluded from what counts as fair and just. Okay, so Rule 2 is a classic way in which the tribunal is forced to act fairly by its procedure rules. Forced, or at least forced to act fairly when it's carrying out any power given to it under the rules. So just going back a couple of slides, I said the first way in which first legal source of procedural fairness was the procedural rules. We've talked about those now. It's also important to remember that another way in which fairness may come up is sometimes the rule which is at the heart of what your appeal is about will have a fairness point. For example, where a claimant fails to attend a medical, then you're allowed to treat them under the benefit rules as not having limited capability for work. But you're not allowed to do that unless they have been given proper notice of the medical appointment and it was unreasonable for them to attend it. Again, those rules build in fairness. They make sure that people don't suffer a loss for failing to go to an appointment that they knew nothing about, okay, or which they could not go to. Now, it's worth saying, and I think I did say earlier, that the procedure rules try to specify what fairness is, but they don't do it in a complete definition. And they also say, look, whenever you use these rules, then the purpose is to be fair. So we know that the end which the rules pursue is fairness, but that's not the only time that fairness arises or the only legal source of the requirement to be fair. Really, at its core, the core of why a tribunal must act fairly is a basic principle of the common law, which is referred to as natural justice. I'm sure it's a phrase everyone's heard. We're going to spend a little bit of time looking at it. And alongside any discussion of natural justice now, you must always also consider Article 6 of the European Convention on Human Rights, which is the right, effectively the right to a fair trial. Okay, so it's the text of the article is there on the slide. In the determination of your civil rights and obligations, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. And the things that you have a right to appeal to about your benefits, those are determinations of your civil rights. So benefit appeals fall squarely within Article 6, and therefore you should have a fair hearing before that type of tribunal. Okay, so what is the content of procedural fairness? I guess one way to start this is by saying that very often a failure to follow a procedural rule will lead to an unfairness. That's not surprising given the purpose of the rules, as we've seen, is to enable tribunals to deal with cases fairly. But it's not automatic. So, slightly different thing. It wasn't a rule within the rules, but within practice statement on records of proceedings. A failure of a tribunal to keep a record of proceedings although tribunals are supposed to, under the practice statement, keep the record of proceedings and provide it to the parties on request, a failure to do so is not an automatic unfairness. It's only an unfairness if you need it, or you can show that I need that record of proceedings in order to work out if my tribunal erred in law. So, for example, one of your potential grounds of appeal would be this tribunal said that I said something in the evidence, and I didn't say that. So they've taken into account, they've fantasized or hallucinated a piece of evidence that wasn't evidence in my case. You would be able to prove that that was the case from listening to the record of proceedings. If you don't have the record of proceedings, that is unfair because you cannot prove the error you're alleging. Okay, but the point of that example is it's not automatic that a failure to follow a procedural requirement will be an unfairness. Okay, so we always need to look when we're trying to establish have things been fair or not. Was a procedural rule followed? And then we've got to go on and show if it wasn't, how unfairness resulted. Similarly, if we want to make sure that a procedural rule is followed, we should also explain why it would be unfair not to follow it. Okay, so I've just done those two sub-bullets in opposite order. Well, I hope you follow that. A little bit more about the content of procedural fairness. Here I have attempted to put the content of procedural fairness on a single slide. And I've tried to say, look, you can analyze this under natural justice, or you can analyze it under Article 6. The process is fairly similar. I've said natural justice includes two things. Firstly, an opportunity to present your case, and secondly, that the tribunal should be unbiased. In Article 6 terms, those two things are a fair hearing and an independent and impartial tribunal. Very often when you see discussions of natural justice, people give a third limb. Interestingly, they give two different third limbs. One is that reasons should be given for decisions, or decisions should be explained. And the other is that decisions should be based on evidence. I've left that out. I'm really talking about those two parts of procedural fairness that I've got on that slide. Okay, so what does it mean to have an opportunity to present your case? It's just an opportunity to present your case. I'll come back to that in a moment. But in order to be able to present your case, it's often said that you must know the case against you. You must be able to have time to prepare your case, be able to attend or participate, be heard, and sometimes that you would need representation. I'm going to go through those in a little bit more detail. But just to flag up that for something to be fair, all that's required is you have an opportunity to present your case. If you don't take up that opportunity, you choose not to, then an unfairness hasn't necessarily resulted. So if you choose not to attend a hearing, you've had a chance to do so. The fact that you are not heard does not render the result unfair. Okay. So just that was an opportunity, but let's just go through what does it mean I've been able to present my case. The first bullet there, I've got first sub-bullet rather, is I know the case against me. Let's talk about what that means. Quite a lot of information on this slide. I'll run through it. The first requirement is in order to understand how to put your, maybe just a step back and say, why do you need to know the case against you in order to be able to put your case? Okay, just think about it this way. An appeal is always against a decision. The claimant is trying to show that the decision of the Secretary of State or the local authority, if it's housing benefit, is wrong. It can be wrong either because they've got the law wrong or because they've misunderstood what the true situation was. So either wrong on the law or the facts or a combination of them. In order for you to show why that decision is wrong, you need to understand what the decision is. Why do they say I don't get benefit? Okay, so that requires, and I've tried to pull out a little bit more here, the different elements of that. First of all, you've got to have the documents which the decision maker had to make the decision, plus the rules say anything else that is relevant. Is a document relevant or not? That can sometimes come up in these sort of cases. I've popped on the first bullet there a reference to JC and Secretary of State for Work and Pensions reported decision of 2016. That case is about cases where someone's been getting, say, ESA for many years. In the appeal bundle is only the most recent medical which found them fit for work. Okay. Is it unfair? Have they been deprived of the ability to know the case against them for them not to have been given the previous 4 or 5 medical reports? The answer is possibly, if it's the claimant's case that their health is no different, because then they're saying their evidence is those previous medical reports are relevant. Additionally, if the DWP submissions mislead the claimant about what the law is, that will be an unfairness. A classic example of that is in TM and Secretary of State for Work and Pensions. That's the case where claimant in a PIP appeal isn't told how the scoring system works, and in fact is pointed to a set of draft Social Security PIP regulations which don't include Reg 4 too big capital A, so they don't know about reasonably, reliably, safely, etc. They're not told about that. That's unfair. One side hoodwinks the other about the law. There are various situations as well in which a case might be unfair because the claimant is surprised by a new point. Now, you could put this one into, as I've done with this slide, the heading of knowing the case against you. You could also think about it as having time to prepare for the case against you. So the examples I've given there, 3 examples, and I'm going to talk about the inferences one separate. Okay, First one is, let's just say the tribunal is deciding the case against you, or decides the case against you, and in doing so, does it on the basis of a legal route or a point which the other side did not take, perhaps making a worse decision for you than either the one which you've appealed or the one which the DWP had offered to make or encouraged the tribunal to make. Classic of that is the case of DO and Secretary of State. I was the representative in that. This was a claimant whose was he didn't have an award of PIP. DWP offered to give him standard rate daily living. I'm going to mess the facts up in my own case, but I might be slightly out, but basically DWP offered to give him standard rate of daily living. He got to the tribunal, and the tribunal, he said, no, I don't want standard rate daily living. I want also some mobility. Anyway, he goes to the tribunal, and tribunal don't even give him standard rate daily living. And the finding of the judge is that should have formed the starting point for the tribunal. So it was unfair on the particular circumstances to give him less than had been promised, or to not adequately warn him that you were going to do that. That's similar, MS and Secretary of State for Work and Pensions. If the tribunal is proposing to make a worse decision, must give you chance to prepare. So that I guess the difference between DO and MS is one is a worse decision than was actually made, and that's MS, and DO is a worse decision than the one which you were offered, even if not worse than the decision against which you've appealed. And then the other thing is the tribunal should put non-obvious inferences to the claimant. And I've got some extra slides about that. I'll go through them now. So these come from the case of CC and Secretary of State for Work and Pensions, which was referenced on the last slide. And the judge in CC kind of reviews the law to point out when it is that a tribunal should put to the claimant, should tell the claimant, look, there's this bit of evidence, and we are minded to conclude from this bit of evidence that this other thing is also true. Okay, so classic example, your client went for a holiday, they flew from Heathrow Airport. The tribunal is minded to conclude from this piece of evidence that they went to the holiday that the claimant is really able to walk a long way because the tribunal has flown from Heathrow Airport, or members of the tribunal have flown from Heathrow Airport, and they know you do a lot of walking in Heathrow Airport. Should they tell your client or not? Well, if they do tell your client might say, I got the mobility assistance at the airport, which would actually be evidence of their difficulties walking. Okay, so you can see why that's what makes it fair to put an adverse inference to a person, because then the person might be able to bring some counter evidence to show that the inference, the going from A to B that the tribunal were minded to do, is not fair. Okay, but the judge reviews it and she says, look, it's not every case where you have to, natural justice requires you to tell the claimant that, see this piece of evidence, it might lead us to decide this. Okay, but there might be some ones where that is the case. She gives examples. The tribunal which wants to rely on a new piece of evidence which the claimant hasn't seen. Okay, such as tribunal wants to look up Google Maps. You would need to have a chance to comment on that for the reasons she gives. Might be a shortcut not shown on the map, etc. Then separately, so that's new evidence. Separately, the judge deals with credibility. This is about whether the tribunal believes your evidence. So there's one thing about your evidence that the tribunal are going to alight on and say, because this is not true, then something else is not true. It's that sort of reasoning. And what she says is they don't have to ask about every single thing they might infer something from. What they need to do is make sure it's fair. And the key bit is where the adverse implications for the claimant's case might not immediately either strike him or a representative, then it may be contrary to the rules of natural justice. But where you see the evidence and it's obvious what could be drawn from it, you don't need to expressly draw that to the claimant's attention. Classic example. Claimant who sits for an hour in the hearing, apparently completely comfortably. There's no evidence that their health has improved since the date of decision. That claimant is relying on the cannot stay at a workstation provision in a WCA appeal. Do you need to put it to the claimant? Probably not. So there is what is said about CC, about those sort of inferences. It's unreasonable, unrealistic to say you shouldn't put them. There have to be particular circumstances present before it's necessary as a matter of law to give a claimant an indication that you could be making an inference, adverse inference from a particular piece of evidence. Something new or something outside the tribunal room, etc. Okay, so there's room for argument about inferences and whether there was fairness, but the test is always, should it have been obvious to the claimant, really, that they could draw an inference? Was the claimant surprised? Okay. So those are my slides about what it means to have an opportunity to understand the case against you. Next is that you must have sufficient time to prepare. Relevant to that, it's the case of CDLA 1238 2007. So the claimant there had only recently appointed a representative, and the judge highlights that was relevant. On the issue of a right to attend a hearing, also part of fairness, always you need to always look at the actual rules. You'll see that the rules they always have a fairness part within them. The tribunal considers it's able in Rule 27, or it's in the interest of justice in Rule 31. Just a note on paper hearings. So that's when the paper doesn't talk. But anyway, you know what I mean. Hearings without or decisions without a hearing is the modern way of saying it. So just a reminder, Rule 27 says, there it is, each party must have consented to or not objected to the matter being decided without a hearing, and the tribunal must be able to consider that it's able to decide the matter without a hearing. That means when it uses that rule, it has to be able to think that it would be fair and just to decide the matter without a hearing. And so in MM, the judge makes the point, it's not good enough for a tribunal in the statement simply to say, you didn't ask for a hearing, so we didn't give you one. They also need to show that they have considered whether it is fair and just to proceed without the appellant. That might be just a couple of lines, but it needs to be there. Then we have two examples of things that could go wrong, where has the claimant actually said, I don't want a hearing? In RA and Secretary of State for Work and Pensions, the issue was there any ambiguity in what they'd said about whether they wanted a hearing or not? You can get cases, for example, where the claimant might say, I'd like to go, but it's too far away, because they think they're going to have to go to Bradford where they submit the appeal or something like that, even though they live in London. Similarly, in SS and Secretary of State for Work and Pension, the claimant had said, I'd like to go to the hearing, or so I can't go to the hearing, but I would like my husband to represent me. And the tribunal had treated that as a request for a decision without a hearing. Obviously, claimant has a right to be represented. That's Rule 11. There's nothing to stop a representative going in the absence of the appellant. Tribunals might not like it, but it is a right. Okay. Maybe then just on Rule 31, proceeding, claimants asked for a hearing, doesn't turn up. Key thing is there a good reason for not turning up? If the claimant has a good reason for not turning up, it will in general not be fair to proceed without the claimant there. LR and Secretary of State's a case to look at for that. On the right to be heard, I've pulled out Rule 11. Rule 11 is the rule in the procedure rules which gives you a right to be represented. It's worth having in mind the words of Judge Jacobs or Commissioner Jacobs, as he then was, in CIB 2058/2004. In that case, the tribunal had been faced with a request for an adjournment by a representative, and they'd said, well, we're used to taking evidence from unrepresented claimants, so that's not a reason to adjourn. Okay. And the way the judge deals with it, Commissioner Jacobs deals with it, is he says, look, reps do more than just help a claimant give evidence. They act as a companion for the hearing. They can help the tribunal by asking questions, including of the DWP, and they can make submissions about what the law means and about why evidence should be referred. Okay. The tribunal, in deciding in a way that the only role of a representative was to help ask questions, but it said that to the claimant, and the claimant then agreed, okay, I don't mind going ahead without my representative. The tribunal really misled the claimant as to what it is that a representative might have helped with, and therefore that was unfair. It's worth remembering that Rule 11 is not a right which pays for a legal representative. You can get, however, a legal aid certificate in the First-tier Tribunal if the circumstances of the case meet the Lord Chancellor's guidance on exceptional cases funding, which is basically, it's necessary to prevent a breach of convention rights. And usually the convention right in issue is going to be Article 6, necessary to have a lawyer in order to ensure I have a fair hearing. The classic case on that is a case Public Law Project did challenging various cuts to legal aid under Legal Aid Sentencing Punishment of Offenders Act 2012, the LASPO Act. And they summarize what it is that Article 6 requires in terms of when will it require payment of a lawyer. Okay. They say the right to a hearing has to be right to a fair hearing has to be a practical and effective, not a theoretical right. So the question is always whether your client's appearance before the tribunal without a lawyer is going to be effective. Is the claimant going to be able to present their case properly? You look at the whole of the proceedings. It also needs to look fair. So needs to not just be fair, but have the appearance of fair. And there has to be a reasonable balance between the positions of the party, equality of arms. And they also say that, look, sometimes our specialist tribunals, because they adopt an inquisitorial approach, are able to ensure fairness even when some of those factors are not made out. But, you will get cases, very, very complicated cases in the first-tier tribunal where perhaps for fairness to be achieved, there should be a legal aid certificate in place to pay for a barrister, whatever. Okay, so that is my summary of what opportunity to present your case means. Quickly, the other limb of procedural fairness is that there should be no bias, or the tribunal should be independent. In the human rights terms, what does that mean? Usually, there are two ways in which bias is discussed. There is direct or express bias, and separately, there is indirect, or sometimes called implicit or apparent bias. Direct or express bias, you're never going to see that. That's where the judge has something more than a trivial personal interest in the outcome of the benefit appeal. Classic example, the judge is your landlord. It's a housing benefit matter and the judge is your landlord. Obviously, judge awards you housing cost element or housing benefit. You are then going to give that money to him to discharge your rent liabilities. Judge has an interest in the outcome. Okay, not allowed. Doesn't happen really. But more importantly, we have apparent bias. And the kind of long established test for apparent bias is, would a fair-minded and informed observer who knows the facts about what's happened in terms of how the case was conducted, would they conclude that there was a real possibility the tribunal was biased? I just want to highlight just three ways that might come up. Perhaps the most common way is the tribunal allows itself, or gives the appearance of, having already made up its mind. That is a closed mind. The tribunal says you cannot possibly win this appeal at the start of the hearing. It looks like the tribunal has made up its mind. The trick is there is sometimes a subtle difference between a tribunal saying, look, this is roughly how we're thinking about your case, and a tribunal saying we've already decided your case. Tribunal that says, oh, we've got a problem with this bit, is actually not got a closed mind. It's inviting you to change its mind. Okay, so those can be subtle. Another one we've got, PZ and Secretary of State for Work and Pensions. This is an odd case. Here, the judge had asked the claimant a number of questions about how he had travelled to the UK when he migrated here. And the representative said, look, why is that relevant? We're here on a PIP matter. And the judge said, that's none of your business. I get to ask the questions. And actually, the Upper Tribunal sets it aside on the basis that a fair-minded and informed observer might think that this particular judge might hold views about immigration, which might have influenced his decision-making about this immigrant's entitlement to benefit. Okay, not something that's going to be common, but there you go. Separately from that, we have a number of cases which talk about bias and when judges should be remove themselves. I'm not going to talk through them. There's the case reference. A key point it makes is that If a claimant or their rep doesn't complain about a particular judge hearing a case because they might be biased before the hearing or during the hearing, it's unlikely they'll be able to assert when they've lost that the judge shouldn't have dealt with the case. Okay. So having discussed the content of procedural fairness, that brings me on to just a couple of slides about procedural fairness in practice. I'll come on to post decision if you've lost and you think there's been a procedural unfairness. But maybe a better way to think about it is when you're running a case, to just be aware of thinking through procedural fairness. So think about when you get the papers, how is my client, how am I going to be able to help my client to have an opportunity to present their case? Have they had the case against them explained? Have they been given all of the documents? Are there inferences that might be drawn from this evidence that my client might not be aware of? I need to ask them those questions so we can prepare for them. Am I prepared to query the relevance of a judge's questions in a hearing? Have I explained what help my client will need in order to participate in the hearing? And then I guess another point that perhaps I haven't emphasized as much as I could have done as I've gone through these is sometimes the presence of the representative will change what counts as fair. Classic example of that would be that case where it was held to be fair or unfair because a tribunal hadn't explained the PIP rules or the DWP hadn't explained the PIP rules to a claimant. If that claimant had had a good representative, that wouldn't have come up as an issue because everyone would have assumed the representative would have explained the PIP rules to their client. Okay. But just then, obviously, the other point to be aware of is procedural fairness is obviously also a ground of challenge against a first-tier tribunal decision. So it is an error of law for a first-tier tribunal to commit or permit procedural or other irregularity which is capable of making a difference to the outcome or to the fairness. Okay, so if something has happened that made a difference to fairness, that is an error of law. Come see me at the Upper Tribunal project if you have cases where you think that's happened. Okay, that's all I've got for you. Hope it's been useful. Yeah, that's it. Thanks.